On behalf of Brinks, Hofer, Gilson, and Leon, welcome to today's virtual panel discussion entitled Patent Enforcement After Passage of the America Invents Act. I am pleased to be joined by today's presenters, Charneski, Tim Delaney, Anastasia Heffner, Lyle, Vander, Schaaf, and Reiziss. Today's virtual panel offers 1 hour of CLE credit in Illinois. We are happy to apply for CLE in other states at your request. Please note the window below the video that states CLE tracking. There will be random check-in points during the discussion where you will be asked to enter basic information into the window provided to prove your attendance. After today's presentation, your CLE certificate of attendance will be sent within 10 business days. We welcome your questions. Submit questions throughout the program via the chat window on the right-hand side of the screen. Our panelists' bios and today's presentation can be found in the top right of your screen. Click there to download them at any time during the program. And now, today's presentation, Patent Enforcement After Passage of the America Invents Act.
Hi, this is Stacy Heffner. Thank you for joining us. There are several avenues in which to enforce a patent. Today we're going to be comparing the relative advantages of district court versus the International Trade Commission, or ITC, and under which circumstances a party may want to litigate in one forum over the other. Along with that, we're also going to therefore provide an overview of the ITC itself and what it is, what the requirements are at the ITC to enforce a patent as opposed to district court, and how the America Invents Act will affect which forum a patentee may select. So why don't we get to it and start with, can we briefly describe for our listeners what is the ITC?
Okay. Well, good afternoon. My name is Charneski, and until recently I was a judge at the ITC for 4.5 years. And the reason I mention that is, as we talk about what the ITC does and doesn't do, it may be that my perspective of how the ITC works is different from counsel here who litigate before it, and I wouldn't be surprised if that were the case. I'll just give a thumbnail sketch of the ITC because the purpose of this panel is to give it some life, to do the backfilling, to paint that thumbnail sketch, because the ITC is a very, very dynamic institution. Bottom line, the ITC administers the Section 337 of the Tariff Act of 1930, and it's been amended. And the reason why the ITC is so popular, and if not popular, it's noteworthy, is the powerful remedy that the ITC has. At the outset, to let you know, the ITC can prevent the importation into the United States of products that are found to have infringed a valid and enforceable United States patent. So that gets everybody's interest. With that knowledge as to what the ITC, the bottom line power of the ITC is, I'll just give you a brief explanation. From the top, and I guess the ITC would like the explanation this way, would be the 6 commissioners. The 6 commissioners act on behalf of the agency. The resolution of all disputes constitutes final agency action. How do disputes get before the commission? A complaint is filed. A complaint's filed by a holder of United States intellectual property. We'll get into the substance of the complaint, what has to be pled, what has to be shown. And within 30 days of the filing of the complaint, the commission is going to either institute an investigation or it's not. I can't recall an instance in which the commission hasn't instituted an investigation. So essentially, if you feel that you're going to be a named respondent in a complaint filed with the ITC, I think it's time to start preparing for trial. After a complaint's filed, 30 days passes, a notice of investigation issues, and at that time the commission assigns the case to an administrative law judge. The administrative law judge is in all respects a trial judge. The trial roughly lasts from day 1 through month number 10, approximately 1 year from the initiation of the notice of investigation. A decision will be rendered, and thereafter an appeal will go to the Commission and to the Federal Circuit Court of Appeals. There are a few nuances about how the ITC works. Jurisdictional requirements are somewhat different than district court, and we're going to get into those in substantial detail. So overall, that's a brief introduction. The ITC is not as mysterious as some people would think, but because it's really a high-stakes game. A lot is wagered by the parties, and a lot is won or lost in a very relatively short period of time. And that's what really actually scares a lot of people when they hear they're involved in an ITC action.
And I think it's important, slide 3, if you'll go to that, Stacy, provides some of the mechanical issues related to the commission. It's an independent agency. Of the 6 commissioners, no more than 3 can be from one political party. They each serve a 9-year term. Those terms are staggered. They get their budget directly from the president. They're not beholden necessarily to the president and his budget, so they go directly to Congress for their budget. The chairmanship is only a 2-year term. It rotates from one commissioner to the next, from one party to the next. Currently we have 3 Republicans and 3 Democrats. And so it's very much very important in the eyes of Congress and in our commercial system that the ITC be independent. And so this fabric of the agency was set up so that the ITC would be independent. And that resonates through to their decision making in the Section 337 cases on patents. It's very much an independent agency.
Okay, thanks, Carl and Lyle. We're going to jump around a little bit and move to slide 13. Moving on, why don't we discuss briefly what are the unique requirements to bring an action at the ITC as opposed to district court?
Sure. Well, of course, you have to prove infringement in the case of a patent, copyright, or trademark case. In addition to that, the unique requirements of the ITC include importation. So you need a product that's either been imported to the United States or where there's been a sale for importation into the United States, or a sale after importation in the United States by the owner of the goods. The second principal requirement is the domestic industry requirement. And you can go to the next slide, thanks. And the domestic industry requirement has effectively 2 prongs that the ITC refers to them as prongs. The first is the economic prong, and in that instance you need to establish some economic activity in the United States. It can be through manufacturing, although fewer and fewer cases, I should say, involve actual manufacturing in the United States. Instead, it can also involve exploitation of the intellectual property in the form of engineering, research and development, or even just licensing of the intellectual property right. That is sufficient to establish a domestic industry on the economic prong. For those cases that involve patent, trademark, and copyright, there also is what they call a technical prong. And what that means is that you must establish that, that you are in fact practicing at least one claim of the patent in the case of a patent, or that you're using your mark in the case of a trademark. On the patent side, you don't have to practice a claim that you assert against the respondents. That's an important distinction. So long as you practice one claim of the asserted patent, it need not, again, be one that you're asserting is infringed. Another requirement that's unique to the ITC, and this is in cases that do not involve registered IP. In other words, it's a case that does not involve patent, trademark, or copyright, so such as a trade secret case. In those cases, Congress left in place the requirement that you also show injury to your industry. And that can be done in any number of ways: price decline, volume decline, market share decline, anything to indicate that the imports have harmed your domestic industry. And that also can be the threat of injury. You need not have present injury if you can demonstrate, and we've done this successfully on behalf of several clients, that there is a threat that the imports will cause you substantial injury in the immediate future, or near term, I should say. And finally, there's public interest concerns. The ITC at the end of the process may decide that it wants to modify the order it puts in place, or not have it apply in certain respects if there's a significant, and I stress significant, public interest concern that's raised. They've only exercised that restraint 3 times in the history of the ITC, and it's cases where the exclusion of the product would have been such as a burn bed for burn victims, and there wasn't enough U.S. supply of the product. And in that case, the Commission said, well, yes, it's infringed, but we're not going to deprive burn victims of beds. But again, very rare, only done about 3 times.
So then, just to follow up on that, would it be enough for a respondent who's litigating at the ITC to establish that one of the elements you just discussed is missing, that a complainant's failed to prove that?
Well, again, if you don't need to show injury, you don't need to show injury. But in those cases, you have to establish each one of these criteria are met in order to get a finding of violation of 337.
Haven't they watered down the domestic industry requirement? I mean, we've seen that there are a number of licensing entities that are going to the ITC. You're not really preventing, they don't really have a domestic industry that they're protecting. They're not manufacturing goods, they're not selling goods. All they're trying to do is monetize their patent portfolio.
Yeah, no question about it. The ITC has allowed not only just a licensing entity to come in and just assert their patents based on the fact that they have them licensed, even if it's a part of a portfolio, that could be sufficient under most circumstances. But in addition, they have held that under certain circumstances, even litigation expenses that are clearly tied to a licensing program would count. So, simply suing, if you can demonstrate that your intent has been and that you've obtained licenses as a result, can be sufficient.
And so you also see a number of foreign, what we would consider to be foreign entities coming into the ITC as complainants. Even though they produce their product abroad, they have enough domestic activity associated with their product, and they have a U.S. patent, so they qualify to be a complainant at the ITC. And now we're seeing probably more than half of the cases filed by companies that people in the public would probably associate with being a foreign party, not a U.S. company per se.
But Jay, on that point, is the Commission sort of, taking a more strict position regarding licensing? And I'm referring to the 694 decision. I think Pioneer, a Japanese corporation, was the complainant, and Garmin, Kansas-based U.S. company, was the respondent. And in that case, as I recall, the Commission held that there was no domestic industry because the patent portfolio offered by Pioneer didn't show or didn't explain that the licensing efforts were that there was enough of a nexus between those licensing efforts and the patents asserted in the litigation. And why I find that interesting is, I'll make the admission, I was the judge in that case that got reversed. And what was interesting, throughout the course of that hearing, there was nothing unusual. It was the same type of evidence regarding licensing that I had heard previously, the same type of evidence, the same type of arguments that the parties had offered to show domestic industry. And it just caught me by surprise with the Commission's holding, and I'm sure it caught the parties by surprise. But what that indicated to me was that the Commission has decided to start to evolve its approach on domestic industry. And I don't know what the next step is going to be, but to me that was sort of a major deviation, because the Commission seemed to be looking for the opportunity to make that statement, and it shows it in the 694 case.
Yeah, no, I think that's right. As their docket has grown, they're paying closer attention to these requirements, and domestic industry is one of them for sure. And I agree. I was surprised that they decided to review and revisit that issue. In my view, they didn't give the parties sufficient warning that they were considering a change in precedent.
Well, that's the point I thought, because during they might have gotten a different evidentiary record. And possibly if the commission, should they speak at an event or the chairman, I think it would be a good idea if they would sort of flag particular issues so that to let the interested party, let the public know that they may be moving in a particular area and that they have interest in a potential change of law. And I think that would be quite helpful to the development of the jurisprudence under the ITC.
We're going to come to that, the trends and how they're going to affect the requirements and the proofs. But to move things along a little bit, seeing we've been discussing the various elements required at the ITC, why don't we take a step back and let's discuss when would a party want to bring an action at the ITC as opposed to the traditional district court venue?
Well, you know, one of the things to take into account is obviously cost. I don't know if anybody else wants to chime in on this, but one of the slides we have provides just from, we've got a lot of factors that are taken into account, but at least with respect to preparing the complaint, I have slide 11 and 12. The list of requirements to be included with your complaint when you're the complainant is much more detailed than what you have to submit to a district court. You have to pretty much vet your case. You have to provide evidence of importation. You have to provide evidence with claim charts of infringement of at least one product shipped by the named respondent. You typically have to do an infringement analysis with respect to each independent claim with claim charts. And then you have to provide the file history of the patents involved and the references that are referred to. And so the details provided in these slides 11 and 12, I could go on all day about the requirements in a complaint, are much more detailed than in district court. So from a cost standpoint of filing the case, you're going to be looking at much more of a burden and much higher costs to file at the ITC. But in the long run, there are other advantages and disadvantages to filing at the ITC. And I'll let some of the other people, if you'd like to chime in on some of the benefits of the ITC.
I'll jump in just real quick on that one. Because the ITC cannot provide monetary relief, it only can provide injunctive relief. I think the iPhone wars are a good example of the type of product that complainants are bringing to the ITC. Products that are going to have a limited shelf life before they become obsolete. And I think what the audience will get from this panel is the speed at which the ITC proceedings are conducted. If we look as day one, as the day the commission says, begin the investigation, start the case, the complaining party, the complainant, will have a decision on infringement within 1 year's time. And that is remarkably fast.
I'm going to jump to slide 6 where we get into
so there are
the speed of relief.
Economic reasons related to coming to the ITC. And again, the speed would play very much into that.
Well, for the district court, besides the obvious, which is damages, I assume there are other advantages where a party would want to perhaps go to district court. Maybe we can touch on that a little bit too.
Yeah, I mean, Stacy, I think sometimes you've got a client who's got a product that has a very limited time frame. Maybe it's a season where he needs to make sure no one comes in and jumps in the Christmas season, for example, with a new product launch. And if someone jumps in and Christmas ends, he may have been damaged and it may be all over. In that instance, in a district court, you can go in there and try and get a preliminary injunction or a temporary restraining order, which can be done in a matter of a few months, which is even quicker than the ITC. Now, I know there are some situations in the ITC where you can ask for preliminary relief, but it's my understanding that that's not very often, they're not implemented very often.
Yeah, the standard's
right.
pretty high for that.
Right. Whereas in a district court, there, you know, if you go to a court where the judge has some time, you get a hearing scheduled very quickly, and you can get some relief in a very short order.
But, you know, to counter that, which is great, we've been talking, you know, about manufacturers, most of whom are foreign. Aren't you going to run up to issues in district court with jurisdiction and the like, personal jurisdiction with some of these foreign manufacturers? What else can we do if you do need to seek that quick relief?
Yeah, that could be one benefit of the ITC. The ITC jurisdiction is called in rem. which means it's jurisdiction over the goods. If you have an import, generally the ITC has jurisdiction no matter where the respondent is located. So personal jurisdiction limitations of federal court do not apply to ITC proceedings. That may be one advantage for parties. You can also name multiple parties easily at the ITC if you don't have to worry about jurisdiction or even venue. Venue problems now creep up in several jurisdictions in district court where a plaintiff will file in one jurisdiction, but the case will be removed for venue purposes to another jurisdiction. You're not going to face that issue at the ITC. And so that could be an advantage. There are other advantages at the ITC perhaps, or at least considerations. We've mentioned the speed of the proceeding. Trial is also going to be in about 10 months. So it's a speed to resolution as well as a speed to trial.
Why don't we?
But the disadvantage of that trial for a plaintiff is you're going to be before a judge. It's going to be a judge trial, a bench trial.
Right.
Whereas in district court, you can get a jury.
Yeah. Yeah, one of the lessons I think we've learned is if you have a patent that is complicated, you should be okay at the ITC because the system is set up to handle complicated cases. If you've got a patent with some invalidity issues and some vulnerability, you have to be careful going to the ITC. I don't know, Tim, you probably have more experience with district court, with juries on invalidity issues, but sort of simple answers that require a complicated analysis don't work well at the ITC. You're going to be outed at the ITC, so you have to be careful if you've got vulnerable patents going to the ITC.
Yeah, I think that's true. I mean, with a jury of lay persons, sometimes a complicated invalidity defense, even with a lot of merit, is going to be very difficult to communicate to a jury. And even the best litigators are going to have a hard time persuading. So in those instances, it would be advantageous to be able to make those arguments to a judge, particularly a trained judge in the law.
And also post-eBay, if you think you're going to have difficulty getting an injunctive relief in district court, of course at the ITC, injunctive relief is automatic once you win, no matter what. And if you think your damages may be limited, as the Federal Circuit and other courts are looking to narrow damages generally, again, the injunctive relief becomes more appealing, and that's what the ITC does.
In fact, that's what we've been dancing around, and you're exactly right. I mean, what the ITC can provide is the injunctive relief, a limited exclusion order directed toward the named respondents, a general exclusion order directed toward all infringing parties, and a cease and desist order. So
Let me go to slide 10.
as well as a temporary exclusion order, but that's so rare. It's usually not listed as one of the clubs that the ITC has in store, but it's totally injunctive relief.
And you know, going back, if someone still wants to get a much faster relief that could be available at the district court, but there are the jurisdiction issues, isn't it true? Maybe Tim, you're best to address this. You're not just limited to the manufacturer. Couldn't you hunt down a subsidiary or even a customer if you didn't have to worry about, you know, diplomacy issues? Isn't that also another option if you really were desperate to keep a product out for the season?
Right. I mean, yeah, you can obviously bring in all the affected parties, the suppliers, the customers, and that puts additional pressure, obviously, on a manufacturer where they have to indemnify somebody. They've got other parties in there. It drives up the expense of litigating the matter.
Thank you. Why don't we jump to slide 15 for the moment? With the passage of the America Invents Act, I think the question we're all asking is, what is the trend for actions at the ITC now? You know, increasing or decreasing? And obviously, shown here, looks like it's increasing, or has been increasing.
Yeah, well,
I'm going to let Jay speak, but as an update, as of the end of the fiscal year 2011, 70 cases were instituted. So that gives you, you know, a better background to comment.
for the fiscal year.
For the fiscal year 2011.
Right, these data are annual data, and it's based on investigations instituted. But either way, you can see the clear trend. I think 2009, of course, was a bit of an aberration reflecting, I think, the meltdown in late 08. But as you can see from the trend chart, there's already been more cases instituted, and as Carl just said, it's even bigger number if you look at it on a fiscal year basis. There's already been more cases instituted this year than in all of last year, and the complaints are still coming fast and furious.
And it'd be fair to say it's only going to, especially with the passage of the act now, it's only going to keep increasing. What do we all think about that?
Tim?
Yeah, I think this graph is demonstrative, but I think it's the tip of the iceberg, because I think there's a lot that's going on in the law, both with case law and with the American Invents Act, which is going to push the non-practicing entity, the patent troll, into the ITC. And if you look at the case law, if you look at the slide 16, I mean, there's some obvious things that have done it. The first one would be the eBay case, where patent infringement finding doesn't automatically get you an injunction. So if a non-practicing entity wants to use that as leverage to compel a settlement, they can't do that anymore because they're not likely to get an injunction in district court. But if they go to the ITC, they have that threat to raise over the manufacturer. Then there's the In Re TS Tech case. That was the first case where the Federal Circuit moved a case out of the Eastern District of Texas, which is a favored forum of the patent, the non-practicing entity. So now they're not as likely to be able to retain jurisdiction in their favored forums, which is another reason why they might want to now go to the ITC. Then the Lucent decision and the Unilock decision, which are two decisions that have come down recently, which make it a lot harder to prove patent damages. It used to be an NPE could put an expert up there and he could wave his hands around, rely on Georgia Pacific, and come up with a big damage number. That's no longer going to pass muster, and damages are likely to require a lot of work by an NPE in order to get a damage finding. So I think all these case law decisions are moving the NPE to go to the ITC, and I think the numbers reflect that. If you go to the next slide, I think the American Invents Act will further drive them to the ITC. There's now a new joinder rule which prohibits a favored tactic of an NPE to name a bunch of parties as defendants to a patent lawsuit. That would create an incredible quagmire in the district court. It was very unfair, really, for defendants to defend themselves when they're basically fighting amongst themselves as to how they want the claims interpreted and so forth. It made it very difficult for a party to defend itself. Well, it's no longer the case that they can do that. They're going to have to file a separate case against each defendant. Another thing that the American Invents Act did, if you go to the next slide, is there's now two new things called inter partes review and post-grant review, which results in the PTO taking a look at the validity of the patent. And what happens with respect to these new rules is that it's not going to be an examiner checking, it's actually going to be the board. And it's going to be a very quick review. It's going to be no more than a year or 6 months extended, but it's a law now. I mean, the PTO can't do an inter partes review that goes 2 years or 3 years or 4 years. By law, they're going to be required to be totally done within 18 months. So when you're in the district court and there was a re-examination filed, and we'd file motions to stay the district court pending the re-examination, the district court would say, well, you know, I'd like to, but I don't know how long this re-examination is going to take. It could go years, and it could go years. I mean, I've got re-examinations I've participated in. They're 5 years out and still going, 6 years out and still going. It can go on forever. Now, under the new law, under the American Invents Act, it's not going to go on forever. The PTO is going to wrap it up within 18 months. A consequence of that is courts are going to be willing to stay district court litigations. NPEs that want a quick settlement are going to be frustrated. If they go to the ITC, there are no stays. The American Invent Act isn't going to affect that. So I think there's a big change coming in ITC based on these changes in law. The other thing the American Invents Act does, if you go to the next slide, is they're not done. I mean, I think Congress is telling the country and telling NPEs, you know, we're looking at what's going on here. We don't like it, You know, that we're not agreeing that the patent system was designed to allow non-practicing entities to use their patent portfolio against manufacturers. So we're instituting a further study, and we want you to report back by September of 2012. Are there other changes that should be implemented? And there are likely to be some more changes that will make barriers for NPAs in the district court even higher. And I think will also be another thing that will drive them to the ITC. So I think the ITC is going to find its docket going to skyrocket in the next few years.
Yeah, but doesn't the ITC have limits on the resources that'll prohibit that?
Well, yeah, I mean, they've gone from when I started at the ITC, 2 judges in the mid-90s who they had trouble keeping busy to today where they have 6 judges who are exceedingly busy. I think we're seeing recently some of the target dates. In other words, the ITC sets a target date by which it wants to render its decision, and we've seen those, a little bit of creep in those as well. I think they are starting to run up against some limitations there that they're going to have to address. Everything from courtroom space to staffing concerns. They've given the ALJs authority to have 2 law clerks instead of 1, and that's going to help move motions practice along, that kind of thing. But I think and in their most recent human capital plan, they've recognized the fact that if these trends continue, they're going to have to look at their mission as an agency and reallocate resources, no question about it.
Do you think we're at the point yet where the ITC is getting over, I know they're busy, but are they overburdened yet, would you say, or not yet?
Well, I'll jump in on that one. I would say, while Tim was talking, he didn't say anything that I disagreed with, but the thoughts that went through my mind were the thoughts that Jay raised. People want to go to the ITC. The ITC is at a crossroads, in my view, and unless it offers or provides substantial resources to welcome the newcomers, it's just not going to work. When I had 11 or 12 cases at the ITC, I would be working on motions that my attorney would come in with a motion, and I would look at it and say, do we really have this case? Because each case might generate at any given time 5 or 6 pending motions. And when you handle them, they're replaced by 5 or 6 more pending motions. And you multiply that by 10 or 12, you multiply that, and then you try to fit in the time the judge needs to have a hearing, pre-hearing conferences, telephonic conferences, and there is no easy case at all. In fact, there's no easy motion. It is such a difficult area of the law, and the attorneys who practice before the ITC are so good that it's rare that you can read a pleading and dismiss it without a lot of time and thoughtful consideration. And the courtroom space is just horrific. And I think that's why target dates might be extended substantially more in the future. When I would get a case, it was almost a race within the courthouse. You've always heard of attorneys racing to the courthouse steps. Well, when we would have the distribution of the new cases, all the judges would be running down to book their time in the courtroom. And I often liked to meet with the parties during the course of the investigation as motions would begin to pile up, especially discovery issues. Fine, let's get a courtroom and we'll resolve all these issues. The parties need to have that resolution. But currently, there isn't enough courtroom space. So if we have the popularity that Tim suggests, and I think he's correct, things are only going to get worse, and the reputation that the ITC has, it's going to lose, and the next panel you see will not why the popularity of the ITC. It's going to be what happened to the good old days.
And picking up on that too, one of the reasons that courtroom space and trial time is so critical is that at the ITC, these are such high stakes cases and so complex that many more or higher percentage go to trial than in district court. The settlement rate overall may be 50–60%, and a lot of those settlements will occur even after trial. And so I think that's one of the reasons that they're bumping up against their capacity is the lower settlement rate.
Yeah, at the ITC, you don't lose until the commissioners say you do. So the judge's decision is sort of an intermediate step. And in district court, it's a little bit late after the jury renders its verdict or decision for you to then talk settlement. One side is going to want to talk settlement, the other one is not. At the ITC, even after the judge has made his decision, the 6 commissioners have an opportunity to review that decision, and so you're not then at the same point of, oops, it's too late at the ITC. So a number of the cases do go to trial, and then they settle afterward, whereas I think earlier in the commission's history, you would see parties that would settle before the trial. But one thing that I think the commission has to keep in mind, and it could create a problem, is that if you look at some of the district court jurisdictions around the country, it's not at all unusual for a number of jurisdictions like Wisconsin, Eastern District of Texas, Delaware, Northern District of California, to receive, maybe not so much in California anymore, but hundreds of complaints a year, if not 1,000 or more in the Eastern District of Texas. And if you're talking about hundreds of complaints being filed at the ITC, or even 1,000, like is the case with the Eastern District of Texas, that's going to create a bottleneck. I don't know that the commission is prepared for that level of cases, but it's a possibility, and so they have to be mindful of it. And they're taking steps like having trials at the district court in D.C. as opposed to at the ITC because of limits on courtroom space and so forth.
Well, I think some of the district courts, too, experimenting with having judges that will focus on patent-based cases will help move things along in district court as well. You won't have a judge who says, I just don't want to deal with this case, and finds every excuse to put it off. So I think some of the actions by the district courts will help make them a more attractive forum as well.
In the ITC, too, they're doing the best that they can with their resources. And it's up to Congress to allocate more resources. And a major proponent of the Commission and the Federal Circuit and the district courts getting more resources for patent cases is Judge Michel, former Chief Judge of the Federal Circuit, is a strong proponent of advancing the various courts' need for more resources.
Do you think with this prediction that we're even going to see more cases at the ITC, the need for more resources, do you think that's going to result in the domestic industry requirement, which we've all said has been somewhat watered down in the past? Do you think that'll be subject to greater scrutiny? And do you think parties, perhaps respondents, will be bringing summary determination motions more often to knock out cases early on that the judges will pay attention to more because of that?
Stacy, I mean, Congress is obviously attuned to the fact that the non-practicing entities is a problem, that they're hearing a lot. There's a lot of lobbying going on from some of the big entities out there, the Intels, the Apple. There's been a lot of complaints, and Congress understands that. So I think the ITC was not, I don't think, on their view screen when the American Invents Act was entered. But if an unintended consequence is that the NPEs now run to the ITC, then maybe you can expect some action by Congress there as well.
And I do think a natural consequence of the ITC's docket getting fuller and them being more overburdened with cases and the judges being more overburdened with cases is going to be that perhaps summary determination will be more freely granted to get rid of cases. It used to be that summary determination was rarely, if ever, granted to kill a case. I think you might see more flexibility with the judges and the commissioners granting summary determination to get rid of cases based on the domestic industry arguments. And I think the commission is going to be more willing to say no to complainants and rule against complainants that they haven't met the domestic industry requirement as a natural consequence of the docket just being so full. I think they're going to be much more willing to say no to certain entities going forward.
But the puzzle or the conundrum is that the solution is the problem. And the cases are so complex, when a summary judgment motion is filed, we're talking about a foot worth of papers and exhibits and a foot worth of responses. And to sit down and carve the time as a judge to really resolve a summary determination issue might take you 4 days. And if you're getting ready for a trial in another investigation, or you're getting discovery calls from someone having depositions in Japan, no matter how you try to focus in on the summary judgment motion, you just don't find the time. But I agree completely with Lyle. I mean, I think that's a wonderful approach, more summary judgment. The trouble is, I think you need more judges. so that you have fewer cases and that the judges can have more quality time to address the really, really fine pleadings that are submitted before the commission.
Okay. I'm going to switch topics for a little bit. I'm going to move on to slide 20. Wrong way. An interesting issue is that when a party oftentimes will file in district court, then decide to bring an ITC action because they do want the injunctive relief. They want to go to trial quickly. And I think an interesting point for our listeners is that typically you can't really litigate in both. Most often is the case. And maybe we want to give a little detail about that and the stay issue.
It's very common for a complainant to file a case at the ITC and file a parallel action in federal court as a plaintiff. But the statute speaks to this. A respondent who is involved in both an ITC proceeding and a federal court proceeding over the same matter, same patents, for example, has their automatic right to stay the district court proceeding upon request. And so there is built-in preference in the statute for the ITC proceeding to proceed and the court case to be stayed. And then the ITC case goes to its conclusion and through appeal, by the way, and then the district court case is unstayed, and the record from the ITC proceeding, including the discovery that is conducted, then is transferred to the district court, and the plaintiff can pursue their case in district court as well, for example, to receive damages. And I guess if they want to continue with alternative injunctive relief, they can pursue that as well. Generally, parties will settle after the ITC decision is made, but there have been cases, and I think our firm has handled a few, where the court case does proceed. There have been cases where the respondent does not move to stay the district court case. They want to hit back as hard as they're being hit by the complainant, and they will not stay the district court case. But there is this provision in the statute that allows a respondent to stay the district court case in a parallel proceeding.
But
Well, go ahead, Tim.
yeah, but Lyle, there is an anomaly in terms of the ITC action proceeding. You get a ruling, you get a determination, but you go back to district court and it's not res judicata. Isn't that correct?
That's
I mean,
correct.
you can go back in district court, and even though they've had this extensive proceeding take place, as a defendant and say you've lost, you can still fight it and raise maybe the same arguments in district court and try to prevail.
That's correct. Now, if you've got a Federal Circuit appeal decision, that would be binding on the district court, but that's a strategy decision that parties take. They go to the ITC, they lose at the ITC as a complainant. The case at the district court has been stayed. They don't file an appeal at the Federal Circuit. They go to the district court and they take another shot as a complainant. If you lost at the ITC, it's not res judicata. You might be able to find a way to convince a jury or the judge to rule in your favor in the district court. So yes, you're right. It's not res judicata, and that could be an advantage for a complainant.
And have we seen that happen? Where maybe you do lose the ITC, but you win in district court?
It's been done that way for the complainants and the respondents, where the one party that lost at the ITC can prevail in district
Right, but I mean,
court.
have we actually seen that happen? I'm just trying to think of a case where
Well,
that
yeah,
actually
our
happened.
firm handled a case where we lost on one claim in the ITC proceeding. Then when we went to the district court, which had additional patents, by the way, we ended up prevailing on that claim for the party because of invalidity issues relating to a additional prior art that came to light.
I was just going to say one interesting side note on the stay provision. It is mandatory in the statute. One district court recently found that unconstitutional based on separation of powers. So we'll have to be continued on that.
But it
front.
he granted the stay anyway on discretionary powers or something?
I believe so.
Yeah.
And I think, talking about the stay, it's important. We said it's the same subject matter and product. I think that's a real important distinction. It's not necessarily, though, the same party. Isn't that correct?
Well, you have to be a respondent in the ITC and a defendant in the district court case.
So if you went after, say, a U.S. distributor in the district court, the same product and same patent, we went after the manufacturer at the ITC,
We wouldn't be able to get that automatic stay.
Okay.
The party would have the right to move for discretionary stay with the judge. There may be other equities involved, but the judge would have to weigh those and make a decision. But
Well,
you're correct, it's
the
not.
the party could try and intervene, couldn't they, in the
Right.
ITC to become a respondent?
They could intervene,
Well,
yeah, and then they could move to stay.
Right, but
if
they
were-
also have to, the ITC does draw a distinction between intervening and intervening as a respondent now as a result of this statutory provision. So you have to satisfy the requirement that you would be named in the exclusion order, and therefore the relief would apply to you directly, and then you can intervene as a respondent and then get the action stayed.
Well, you know, Tim, I've seen dozens of respondents or more try to get out of an ITC proceeding. I've never seen one try to get in.
Well, I was thinking of the scenario where a party who's not named as a defendant in the district court intervenes into the district court case, is then named as a defendant. They are already a respondent in the ITC, and then they can stay the district court case because they've become a defendant in the district court case. I was looking at that scenario where they're already in the ITC, and then they move to be entered in. If they're a manufacturer and their distributor or customer is named in the district court, they probably have indemnification issues anyway, so intervening in the district court probably isn't going to change their situation much.
Now, doesn't an ITC proceeding as a plaintiff, a complainant, I guess, doesn't that cost a lot more than fighting a district court action?
I think it depends. The theory, the ITC proceeding moves so quickly so that if you're the complainant or plaintiff in district court, you cannot stagger your costs out over a longer period of time. If the proceeding takes 2.5 to 3 years, your costs are staggered out over 2.5 to 3 years if you're in district court. At the ITC,
Which helps if you settle early. If you file a complaint in a district court with the goal of stopping someone quickly, and hopefully they'll come to their sense, they don't want to spend on lawyers, which I understand some lawyers are expensive, and you know they get out quick. So for a lesser sum, if you stagger out these expenses, doesn't that lend to the effect that it might be a lot more cost efficient to file in a district court?
yeah, I think especially for cases that ultimately settle, you've put more money into it as a plaintiff and a respondent before settlement at the ITC, and it's less expensive at district court. The other thing that we're seeing at the ITC is the proceeding moves so quickly. Judges oftentimes don't do Markman hearings. You do the Markman type decisions as wrapped up into the ITC trial, and so there's this theory of being all in, and it's an open spigot. You got to go after all the prior art because you don't know what the claim construction is going to be. You got to go after all the discovery because you don't know what the claim terms are going to be and what your theory of infringement is. You got to put in all your defenses because you're not sure again about where things lie. And so it's all in right from the get-go. And as a result, your costs now are relatively higher than in district court. It used to be that the ITC was less expensive because it was a faster proceeding. You didn't have the damages issue for discovery on that. But it has shifted over now with these high-profile, high-stakes cases where you're all in, and it's an open spigot, and therefore your costs are higher at the ITC than they are in district court.
What about the length of the hearing compared to the length of a trial?
The ITC
district
hearings
court.
are 5 days
Probably about the
typically.
same, yeah.
Yeah.
I think the flip side, though, is often when you want to assess whether you should settle or at what rate and what are your risks, both upside and downside risks, you need more information. Okay, a company needs to have more information about their opponent's products, the strength of the patent, that kind of thing. And I think one thing that the ITC does offer is because discovery happens so quickly and with nationwide subpoena power, you create a record a lot quicker upon which you can make an informed decision about settlement. So I think that's a counter consideration.
Well, I'd like to respond to one thing that both Lyle and Tim said, and they're addressing a remedy, okay, in terms of costs of proceeding in district court or at the ITC. I think the problem is with the commission now instituting investigations that are so large, so many parties, so many patents, so many claims, that it's impossible for the judge to really get a good handle. And I've seen in the courtroom where counsel really didn't have a handle of their own case, and I know they're working almost 24 hours straight.
Well, I mean, isn't that a consequence of this American Invents Act where you can't join people in district court anymore? A plaintiff, an MP can't file against 30 people. They're now filing those exact same things in the ITC where you've got 30 respondents.
Well, I'm not saying not to do that, but possibly at least the commission can give consideration, or hopefully the general counsel would offer their advice to the commission's lawyer, that maybe an 8 or a 6 or an 8 patent claim in a containing 100 asserted claims is too much.
Yeah.
And bringing in the complainant and say, institutionally, you're going to kill us.
Like,
So
so
should
how would the commissioner deal with with 30 defendants or 30 respondents in an ITC action? Would that lengthen the time for the hearing? Would it?
No. I mean, you might get an 18 or 20 months, but you're going to lose some respondents. But the point is, I think the commission, I think it would be fruitful for them to consider the importance of preserving the commission's resources, of preserving the commission's notoriety for providing, top legal work, and to say, if we continue to entertain these outrageous complaints that are being filed, and the more outrageous the complaint, that doesn't even stop the complainant in many cases from moving during the hearing to amend the complaint to add more.
Yeah.
I think at least some consideration should be given by the commission to say, is there a way that we can make these cases more manageable so discovery doesn't kill the parties financially, and allow some time for the parties to be able to talk settlement once they get the facts.
Well, I mean, the judge could always just issue an order limiting the number of claims.
But that's a
per
distinction
patent.
between a distinction between the ITC and federal court. Like Judge Holderman in the Northern District here, what's his limit? 9 claims or something? Can't even remember. But he has a limit on how many claims you can assert, and he makes that limitation be imposed early on in the proceeding. That's a difference at the ITC. We're involved in a case that has 7 patents, 139 claims. Well, there's no way that complainant in that case, it's not us, we're representing respondent, there's no way that complainant is going to be able to litigate that many claims at a trial in the ITC. At some point, they're going to limit the number of their claims. But in district court, you're forced to do that very early on. And at the ITC, it depends on your judge, it depends on the case, and there isn't a hard and fast rule currently at the ITC to limit that kind of abuse.
Well,
that's a distinction between the ITC and
depends on
federal
district court as well. I mean, district courts, I've had many cases where there's been no limitations on claims until very late in the ball game. And you ask for them immediately when that's an excessive number, but every judge is not Judge Holderman, Chief Judge Holderman, and some judges allow them to assert as many claims as they want.
But here's the thing, I just want one quick point in response to what Jay said. What a judge could do at the ITC is to limit the claim terms to be construed. The commission determines the mission. The commission says how many patents, how many claims. The judge has no control over that. And only the commission has that authority. Now, whether the judge can do sort of shore things up or tighten things up by saying, fine, too many claims are being construed, we're going to limit that. But other than that, there's nothing a judge can do. He's got to accept the case as given to him by the commission.
That's a good point.
Okay, thank you. I think we're going to take a few minutes. We have a few minutes left to take some questions from people who have them. Feel free to send your questions in, and while we're getting those, I think to build on the burden, we touched briefly on you have crazy discovery going on, the number of patents going on. I think an interesting, maybe question or disclosure for our listeners is how different the discovery requirements are at the ITC, just the mechanics, not in theory. And if anyone wants to address that, I'll start off. To me, one example in cases I've dealt with is where you have a limit, say, of 150 plus interrogatories versus in district court, you don't see that at all. And if we can touch on those and others.
On that, just quickly, when I handled discovery, I never limited the parties. They were so good at bringing problems to me. I knew if they had a discovery problem, they would call me. But by the same token, I never turned down a conference call to discuss a discovery problem. I never enjoyed them, but I never turned them down. And I often inquired from the parties during pre-hearing conferences how things are going in discovery, and just made myself available to be able to resolve the problems the parties couldn't. But Jay and Lyle might be more familiar because other judges at the ITC do things a lot differently.
Yeah, they do. In fact, there is a judge who will not entertain any calls whatsoever on discovery disputes. Will not happen. You file a motion to compel, and you first have to wait 2 days after vetting the issue and put something in a discovery committee report before you can file a motion. Now, there are a number of judges that do put limits on interrogatories, but it's at 175, which is much higher than what the federal rules, 20 or 25, what is it now?
25.
25. So it's a much different ballgame at the ITC, and many of the judges don't even have a limit on the interrogatory numbers, and when they do, it's 175. I think the ITC is probably a little bit more willing to allow foreign discovery. They're a little bit more willing to allow depositions to go past 7 hours and to allow multiple depositions of the same witness. So I think if you're a complainant and you're really looking for a lot of discovery opportunities, the ITC is a good venue. But I think it might depend on the district court.
But you also have to
Well,
keep in
the
mind,
district court, I mean, we've lowered those limits because of the enormous expense of discovery. I mean, the idea was, and when you have to take a deposition nowadays, you've got to check your watch and you have the court reporter maintain that, okay, how much of my 7 hours do I have left? And you've got to be a little bit more choosy about what you ask and what you do. It sounds to me like in the ITC, it's back to the old days of,
But
go ahead.
But not without good reason, and I want to tie in something that Jay said. He said at the ITC, it's high-stakes litigation and you're all in. Now, I might have been wrong in my thinking, but part of my reasoning for letting this fairly wide open discovery, unless there were a problem brought to my attention, is the fact that the parties have so much at stake and they have such a limited amount of time to get information before they're filing their motions, filing their expert reports, and going to hearing. So it wasn't a cavalier attitude or, yeah, I'll think about it when I have time. There was a method. The method may have been wrong, but that was the intention, was the parties need that information because there's just too much at stake and it's going too fast.
don't you even have a little more, doesn't it even become more complex? The one thing we really haven't touched on, and maybe we can briefly do that before we adjourn, is you also have the third-party staff attorney, and that's something unique to the ITC, and I imagine that can also make issues more complex. It's not just, you know, plaintiff versus defendant.
Yeah, they can be a tiebreaker. They
Okay,
weigh in on
explain
discovery.
what is a third-party
Jay's
staff
served
attorney?
in that office.
Yeah, it's the Office of Unfair Import Investigations. I served there for 4 years. And essentially, they're a party to the case, and they participate to varying degrees in the case, but they can weigh in on all motions, practice. They participate in depositions and at the trial, and they take a position on most issues, in some cases all issues, and certainly issues of violation and infringement and that sort of thing. And to some extent, the judges and the commissioners look to them as sort of an impartial participant in the case, right or wrong. That's certainly the role and the way they're looked at. They're revisiting their role on many cases now, in part because of the caseload, and not participating in every case anymore. They used to assign a staff attorney to every case. And their mission technically is to represent the public interest. They're not bound by either side, and they are supposed to call them as they see them. Of course, they're not infallible, but be that as it may.
Okay, and I guess we have time for one more question. How often does the commission overturn the ALJ?
You know, I did a study with another group of lawyers for the ITC Trial Lawyers Association, and I think we came up with a statistic going back over the last 10 years that there's a lot of times the commission will review a judge and they might find, there might be 3 patents and the judge finds all 3 infringe and the commission might reverse on one of those, which keeps the remedy in place,
Right.
and it doesn't really change the outcome for the parties. So we discounted for that, and we really analyzed a lot of cases for the last 10 years, and I think we came up with 26.4% of the time. There's a real reversal by the commission of the judges in the last 10 years. And that of course doesn't count the cases where there's a change that doesn't change the outcome for the parties.
I need 20 seconds. Throw the statistics out the window. When I first started at the ITC, Commission was affirming a lot of the judges, and this is something that Judge Michelle from the Federal Circuit believes that ITC judges that should be given more deference by the Commission. I don't see that happening, and as time progresses, if you notice the questions that are directed for review by the Commission, there are 4, 5, or 6 pages, including directions for of review of one of Judge Luckern's recent decisions, and Judge Luckern, by anyone's standard, is an icon in the ITC world. So I would look at what's, to me, the better barometer is what's happening today, and there's an awful close review. They're looking at an ALJ's decision as if it were his life's work and not a five-week writing.
Okay. Thank you. And on that note, I think we'll adjourn, and I want to thank everyone for joining us. I hope you found it as interesting as we all did. So thank you very much.
This concludes our presentation. Don't forget to download our panelist bios and the presentation before you tune out. And note that your CLE certificate of attendance will be sent within 10 business days. Thanks to everyone for joining us.